Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Martin Shanebaum, and Martin is an attorney specializing in civil and criminal tax litigation. His law firm, Martin A. Shanebaum, a professional law corporation, has been serving the national and international community in civil and criminal tax-related matters for over 30 years. Martin was formerly Assistant United States Attorney in the Northern District of California, Tax Division, and formerly an IRS Regional Counsel Trial Attorney. Mr. Shanebaum and his team of professionals prevent civil tax controversies from becoming criminal matters and battle the government for individual clients, corporations, and other business entities. Martin, thank you for joining me today.
It's my pleasure to be here.
Okay, great. So today I've asked Martin to provide some guidance about what to do if you're audited by the IRS. And we are going to be covering some highlights of a complex subject, so please consult with a qualified tax advisor about your situation when you're dealing with an audit. Okay, Martin, let's get started. So when somebody gets a letter from the IRS, is that a reason to panic?
No, I mean, you might get a letter just for informational to, let's say, supply a missing 1099 or a missing document, or to explain what the item is in relation to what appeared on your Form 1040. So that is not a reason to panic. If you get a letter that says you're under audit, office audit, or field audit, it's of a serious moment and you have a concern, and you need to follow the instructions. You can always change the date of the meeting or the time of the meeting, and if the IRS wants to have the meeting at your home, decline that invitation and instead retain a representative so you can have the meeting at your representative's office. It is not a good thing to have IRS agents come to your home. Over the years, I've seen some interesting consequences where IRS agents have come to the taxpayer's home, viewed the assets, maybe they have paintings or other items of indication of wealth, and then the audit becomes more serious. So the best procedure is to have it at the representative's office, and the best procedure with a formal IRS audit is to hire a competent representative, such as a CPA like Mike Gray, or an enrolled agent, or an accountant, but better still, a lawyer who has been around and understands the audit procedures. So that's what I would say regarding IRS initial audit notices.
Okay. So a question I think that many people will ask is, why me? Why is the IRS picking on me with this notice or an audit? Any thoughts related to that?
Yes. In today's world, you have to expect that at some time during your lifetime and during your business experience, you're going to have an IRS inquiry or audit or examination. There's nothing really sinister about an IRS notice. It could be a random notice. It could be an item on your return that triggers the diff score and causes the return to be produced and referred to examination. The only exception to this is, in many cases, you might be in a business, you might have a disgruntled former employee, you might have a competitor, you might have, in divorce cases, I've seen where ex-spouses go to the IRS and say, he's a nice person, but, and then you get an audit. If that circumstance occurs, you certainly need to get representation immediately. You know, a CPA like Mike Gray will handle the matter, but if he determines that there's some interesting items that may produce a fraud examination, you need to get a lawyer, somebody like myself who's been around and has been in the IRS, been in the Department of Justice, handles civil and criminal tax cases. But that's the only exception.
Mm-hmm. Now, so you've indicated in general that you think it's a good idea for people to get help. Maybe, so, and specifically, of course, related to if we have a fraud situation. I mean, basically what I've been told is if I ever have a fraud situation, tell a client, don't say anything, take him by the arm and drag him to an attorney. So
that's a correct analysis,
yeah.
Because anybody but an attorney does not have the attorney-client privilege. There is the tax preparation privilege under 7525 of the Internal Revenue Code, but it doesn't extend to any kind of criminal matters or tax shelter matters. So your best approach is to hire a competent attorney, because then you have the privilege and the confidences, and you can explain everything to the lawyer, and he or she will be fully advised in the premises and be able to handle your audit accordingly.
Now, we're going a little in a different sequence, but that's okay. So what would be a flag? What would be an indication to somebody maybe this is a tax audit related to a fraud situation?
Well, that would be what we would call an eggshell audit. And an eggshell audit is where the client explains to the lawyer, look, I had this source of income, I'm using the example, and I did not put it on my return. Now, the audit and the revenue agent may be looking at expenses, may be looking at some items of income, but as soon as the agent starts expanding the audit by asking a lot of questions about income or your assets, or do you have a foreign bank account, you have what you call an eggshell audit. And in that case, you want to try to resolve the audit as quickly as possible, and you don't want to be aggressive. If the agent says, okay, you owe X, and you as the client say, but X is too much. But the alternative is it turns into a criminal case, and then what you're facing is 10 times X plus attorney's fees plus accountant's fees. So how, at least we handle eggshell audits, is if we can keep it confined to civil, and whatever the agent wants, we basically say you pay up and close the audit down.
Okay.
There's also a reverse eggshell audit, this is why you really need an attorney. What is the reverse eggshell audit? By the way, I've written on the subject, and you can find it on the internet. It's eggshell audits and parallel investigations. A reverse eggshell audit is where the government knows that you have a criminal exposure, but they're conducting it as a civil case. And in this instance, it's dangerous because normally in an audit you would cooperate, you would provide information, make statements, but in a reverse eggshell, if you start stating items or telling things or providing documents, you may be building a criminal case. A while back, there was a case called Tweel. And in the Tweel case, the attorney asked, is there a special agent involved? Is there a criminal investigation? The answer technically was correct when the revenue agent said no, because what was happening was the organized criminal division of the strike force was handling the case. So in that case, information was provided, cooperation, but then there was a motion to suppress. And the court said basically the taxpayer was deceived. sort of the tax version of consumer fraud.
Mm-hmm.
And they suppressed all the evidence. Today, the Twiel case is watered down. You have to prove an affirmative act by the government in deception. In other words, if you ask the revenue agent, is this a criminal case? And it is, but the agent says, no, it's not. You have an affirmative act. So what's happened is in dealing with the Twiel problem, the IRS has come up with a new version of how to get around it. It's called a fraud technical advisor. So any practitioner has to ask at some point, is there a fraud technical advisor involved? Now, what does a fraud technical advisor do? Collects all the information for the purpose of determining whether there's fraud, and then hands it over to the criminal investigation division. This is a very kind of dangerous procedure. In the concept of substance over form, which is a basic tax concept, this is in substance a criminal investigator in the form of a civil agent. So you need to be at the top of your game, and you need to understand what's happening. And that's another reason why taxpayers shouldn't be handling audits or anything that's sensitive in this regard. So that's just what could happen.
No, so there's a couple things I understand. One, I guess, if there's an indication that the person is from criminal investigation division, that then you know that it's a fraud case in most cases, correct?
Right.
If they're packing a gun, they're the only ones that get to pack guns, right?
Hey, look, if the agent says, I'm a special agent, you know it's only criminal. And at that point, you can cooperate under the Constitution, which means you have a Fifth Amendment right not to incriminate yourself. You got a Fourth Amendment right not to have an unlawful seizure. So what you want to do, if you find out that there's a special agent involved, there's nothing more you can do. Let the agent try to build a case without your cooperation. But the problem is to determine whether or not you have a sub rosa criminal investigation going on in the trappings of a civil audit. And that's why you need to be at the top of your game and understand what's happening. And too many taxpayers go forward and they really don't understand what's happening. And so a criminal case is built unwittingly by the taxpayer not understanding the telltale signs.
I see. So some people I've had indicated to me that they were concerned about bringing a representative or having a representative because they're afraid that the IRS is going to think that they have something to hide. So how would you respond to something like that?
That is a misunderstanding. IRS today, in the 21st century, understands there's a whole lot of representatives out there, CPAs, enrolled agents, and lawyers, and they think nothing of it. In fact, the IRS has a form, IRS 2848, which is a power of attorney, and if you look at some of their notices, they say, if you got a representative, just give us the power of attorney. So I would not be concerned about that. It's almost the same way I've lectured for the American Bar Association, for the State Bar, and a lot of practitioners worry that in an audit, if you say, is this a criminal case, that signals them for a criminal case. Or a lot of practitioners worry about exercising the Fifth Amendment. I am a pro Fifth Amendment person. I will rather ask the question and find out that you got to exercise your Fifth Amendment, because what's the bottom line? If there is a criminal case going on, you're better off knowing early on. It's like one of my past senior lawyers who helped me said, dealing with the IRS is like dealing in wet cement. And what happens to wet cement? It hardens. So if you get in early enough, the cement is still wet and you can have flexibility. You wait and don't ask the question, the magic question. Is this a criminal case? Or exercise your Fifth Amendment, you're going to find out that you have a criminal case and you supplied a lot of damaging information. So it's better to know up front what's happening.
Yeah, okay. Are there items requested by the IRS that taxpayers aren't required to provide?
I just touched on that. There's the Fifth Amendment privilege, especially if there's an eggshell audit or there's criminal potential. However, there's this required records exception that the government's been pushing. So generally speaking, if you have a criminal case and there's a realistic possibility of prosecution, you can exercise your Fifth Amendment, and the government will argue, oh, but those are required records. That's why you have to have a competent representative to analyze what is a required record, how much information is required. That's the only exception, but I would say that the Fifth Amendment is good to go if there's a realistic possibility of criminal prosecution.
Okay, but if you have a more routine civil audit type of a situation, what about in that situation?
Well, you would provide information and cooperate. I mean, always keeping in the back of the mind, is this truly a pure civil? And I have asked in examinations, is this a civil examination or is there something else going on? And I have been successful at times in summons enforcement cases arguing that what's going on here is a sub-rosa criminal investigation. So you really need to be astute as to what is happening.
So one thing that, again, I've been sort of told along the way is that in most cases it's better to just provide what the agent is asking for rather than volunteering a lot of information. Do you have any feedback related to that?
I think that's good advice. I mean, just provide exactly what is asked for and don't volunteer any additional information. I've seen over the years where taxpayers, especially salespeople, believe they can talk their way out of anything, and they keep talking and they keep carrying on.
They bury themselves in the process.
And the next thing you know is they got a criminal prosecution. So what you just said is good. Do not provide anything more than is necessary.
Okay. So there are some cases that people have provided certain documents that the IRS has asked for example, a property tax bill and a canceled check, and then the IRS continues asking for additional information. Why did they do that?
Well, there's a number of reasons. One, they want to make the record, and so that they, when they close the case, their supervisor will be happy that it's fully substantiated. The other reason, the more sinister reason, is they're trying to build a criminal case. So at that point, if they keep asking for more information, you have to ask the magic question. Is there a fraud technical advisor involved? And if the agent refuses to answer, that's an answer itself. That means you have to stop. Don't volunteer, don't supply anything else. The worst thing that can happen, the agent says, look, if you don't give me this extra information, I'm going to write up the report the way it is. My answer is, go do it. But as opposed to adding to it. But you need to ask the magic question. And a lot of practitioners are afraid. They think, well, we're going to
okay. Go ahead.
We're going to embarrass ourselves, or they're going to think that maybe there's some criminal thing. I don't care. What I care is to intelligence, to know where I am. As I said, dealing with the IRS is wet cement. So if it's bad news, you better know about it early on before the cement hardens.
Right. And there are, I guess, some cases where, I mean, if the criminal case is serious enough, you know, you could end up cooling your heels in prison. So is that really worth it compared to, you know, being obstinate and so forth, or you know, continuing on?
Yeah, no, the alternative is if you tell an agent, go write it up, and they write it up and you come out with a dollar number, you might as well, as I said earlier, you might as well pay the dollar number versus what the alternative is, which could be, instead of paying X, you could end up with 10X.
Okay. So we're going to have another program that we're going to talk about appeals and so forth. But why don't we talk for just a moment in this interview about, well, now the audit is completed and you get an audit report. So what are some things initially that you can do?
Well, number one, you could accept the audit report and pay the money, and I told you that's important if there's any criminal potential. Number two, you could disagree with the audit report, request a meeting with the supervisor, and number three, you could disagree, request a meeting with the supervisor, and then tell, we want to go forward with appeal. Now, the IRS will issue a 30-day letter, so you have to make a good strategy decision whether you want to go and protest the 30-day letter. Why do I say that? Because if you go to appeals at that point, there's no pressure on appeals to do anything but maybe confirm what the revenue agent said. My own strategy is, look, I'm going to appeal this, issue a 90-day letter. What does that mean, 90-day letter? 90-day letter gives you the ability, the ticket of admission to the tax court. If you go to tax court, the first thing that happens after you go to the tax court is the IRS counsel will send the file to appeals. Now, if it's in appeals at that point, there's pressure because the court will say, okay, here are some deadlines. The appeals person would like to resolve the case. Even though there may be a likelihood of raising new issues, I have hardly ever seen that in my career. And if you get that kind of a scenario, you probably come out with a reasonable settlement. Especially, I'm known that, and one IRS person said at a seminar, Marty will go to trial. So I've built a reputation that, while I think a settlement is good, and the sooner the better, but if I don't get a reasonable, fair settlement for the client, I will go to trial. And we've done quite well over the years. And so I think that's the better approach, a 90-day letter versus a 30-day letter, and then go to appeals under the tax court umbrella.
All right. So have you seen problems related to people not responding promptly to these notices and then problems falling out from that?
Well, yes and no. It depends on the notice, and it depends on what the problem. I mean, if you fail to.
Part of this is, I guess, because of the nature of your practice, I think that you've gone in and picked up the pieces in some cases.
It's like the Tony Bennett song. I want to be around and pick up the pieces.
Yeah, right.
But it depends on the notice. I mean, if you default a 90-day notice, then you can't go to tax court and you're in collection. If you default some other kind of notice, you might be able to get an informal extension. For example, in the offshore cases, we just have some people who have hard to get the foreign bank accounts and stuff, and the IRS says you have to supply that, but they've been pretty good about giving you extensions. So defaulting time limits depends on a particular notice and how serious it is.
Yeah. So, yeah, I think a big part of what I'm getting at to some degree, though, is that you don't want to really totally blow off notices. Okay, when you get one, you want to respond to it. For example, if you have the trouble getting the information, you want to at least write back to IRS and say, I'm trying to get this information for you, but I need additional time.
No, that's key. What you're saying is it's key to communicate with the IRS. Communication is the key to success. I mean, if you treat the IRS fairly and you communicate promptly, they will work with you. I mean, there are always exceptions, but communication is the key here.
Yeah, and as we're talking about communication, it just brought to my mind that, there are so many people that think I know my situation, so I can deal with this agent and no problem. And in some cases they can. But the thing is that attorneys like yourself and CPAs, we speak a common language with the IRS. And so the communication is more clear, and that's a big reason in itself for having somebody represent you, is that they speak the same language as that agent that they're dealing with.
Right. I think that's important. I think you hit a key thing. I had a former IRS agent who was with me when I was in the U.S. Attorney's Office, and in particular eggshell type of cases, I would have him go to the IRS conferences, just for the reason you articulated, that he spoke the lingo, he understood the dynamics, he understood the risks, and we were always successful. Now, a great tragedy happened. I learned that on November 28th, he died.
Oh.
His name was Thomas Lepori.
Mm-hmm.
Tom Lepori, who was, and it was in the Sunday Chronicle, his obituary.
Mm-hmm.
They said he was a preeminent tax fraud investigator and auditor. No, he was the top. He was the best. He was number one.
Wow.
Because we have a track record with him that we never lost a case when he was involved.
Huh. Wow. Martin, I want to thank you again for joining me as my guest and sharing this very important information with our audience. And folks, I hope that we've gotten the message through to you that it's a good idea to get representation when you're dealing with an IRS audit. We'll see you next time on Financial Insider Weekly.